Question number 751. Section 114 illustration G of the Indian Evidence Act 1872 refers to the presumption as to option A, common course of business, B, arising from withholding evidence, C, regarding bill of exchange, and D, continuity of things. Here correct answer is option B, that is arising from withholding evidence. Question number 752. Under section 114 of the Evidence Act, court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of. Here correct answer is option D, that is natural events, human conduct, public and private business. All of the above are correct here. Question number 753. Which illustration of section 114 of the Indian Evidence Act is based upon the maxim omnia praeseminere rait et solemnister esse acta? Here correct answer is option C, that is illustration E. Question number 754. The court may presume that when a document creating an obligation is in the hands of the obligator, the obligation has been discharged. B, judicial and official acts have not been regularly performed. C, a bill of exchange accepted or endorsed was accepted or endorsed for deficient consideration. And D, all these are incorrect. Here correct answer is option A. The court may presume that when a document creating an obligation is in the hands of obligator, the obligation has been discharged. Question number 755. In which of the following cases the court may presume under section 114 of the Evidence Act that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen? B, that an accomplice is unworthy of credit unless he is corroborated in material particulars. C, that judicial and official acts have been regularly performed. All of these. Here correct answer is option D, that is all of these. Question number 756. Which of the following facts the court shall presume to exist? Option A, when a woman states in her evidence before the court that she did not consent for sex. Option A. Option B, the child will never lie. Option C, a priest will always speak truth. All of these. Here correct answer is option A. When a woman states in her evidence before the court that she did not consent for sex, this will be the court shall presume to exist. Question number 757. A person is seen with the same banknotes immediately after a theft in the bank. The presumption is he has stolen the money, he has received the stolen money with required knowledge, either A or B, none of the above. Here correct answer is option C. Either he has stolen money or he has received the stolen money with required information. Question number 758. Presumption as to absence of consent in certain presumptions of rape cases is raised by. Correct answer is option D, that is section 114A of the Indian Evidence Act. Question number 759. The presumption under section 114A of the Indian Evidence Act is an rebuttable presumption, a presumption of fact, mixed presumption of law and fact, irrebuttable presumption of law. Here correct answer is option A, rebuttable presumption. Presumption under section 114A of the Indian Evidence Act is rebuttable presumption. Question number 760. Which of the following section was not inserted in the Indian Evidence Act 1872 by the Information Technology Act 2002? Here correct answer is option B, section 114A. Other section 81A, section 73A and section 47A was inserted by the amendment in 2000 Information Technology Act 2002. Question number 761. In a prosecution for rape, where sexual intercourse by the accused is proved and a woman states in her evidence before the court that she did not consent, here correct answer is option D. The court shall presume that she did not consent. Question number 762. By which amendment section 114A was inserted in the Indian Evidence Act? Here correct answer is option D, that is none of the above. Question number 763. Section 114A of the Indian Evidence Act is related to presumption as to abetment of suicide by a married woman, presumption as to abetment of suicide by a woman. C, presumption as to absence of consent in certain prosecution for rape. Here correct answer is option C, presumption as to the absence of consent in certain prosecution for rape. Section 114A of the Indian Evidence Act is related. Question number 764. What is presumption as to absence of consent in cases of rape under section 114A of the Indian Evidence Act? Option A, none of these. Option B, a conclusive proof. Option C, the court may presume. And option D, the court shall presume. Here correct answer is option D, the court shall presume. Question number 765. In a case where doctor commits a rape on a woman of 30 years of age under his treatment and a woman says that she did not consent, the court will need proof, shall presume that she did not consent, may need corroboration, may presume or may not presume her consent. Here correct answer is option B, that shall presume that she did not consent. Question number 766. Estoppel has been defined under section 115. Here option A is the correct answer. Question number 767. In which section of Indian Evidence Act the provision of estoppel are given? Here correct answer is option A only, section 115 to section 117. Question number 768. Section 115 of the Indian Evidence Act is founded upon the doctrine laid down in which of the following case? Here correct answer is option B, that is Pickard versus Sears. Question number 769. What is estoppel? Correct answer is option A, that is prohibition from proving a certain fact. Question number 770. The doctrine of estoppel means B. Restriction to make statement contrary to the earlier statement or admission. This is the doctrine of estoppel. Question number 771. Section 115 of the Indian Evidence Act deals with estoppel. Question number 772. When one has by his declaration, act or omission intentionally caused or permitted another person to believe a thing to be true and to act on such belief, neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. The statement of law is well known in the Indian law of evidence as a principle of. Correct answer here is option C, that is estoppel. Question number 773. In which one of the following under Indian Evidence Act is not a kind of estoppel? Option A, estoppel by will, estoppel by deed, estoppel by conduct, estoppel by record. Here correct answer is option A, that is estoppel by will is not a kind of estoppel. Question number 774. In case of 𝐮𝐳𝐝 versus Gopal Chandra Laha 1891 is related to which of the following section of the Indian Evidence Act? Correct answer is option B, that is section 115 of the Indian Evidence Act. Question number 775. Which one of the following is not a kind of estoppel? Here options are estoppel by deed, estoppel by conduct, estoppel by record, estoppel by decision. Correct answer is option D. Estoppel by decision is not a kind of estoppel. Question number 776. Which section of the Indian Evidence Act is founded upon the doctrine laid down in Pickard versus Sears? Correct answer is option C, that is section 115. Question number 777. Estoppel can be attestation, recital in deed, standing by, all of these. Correct answer is option D, that is all of these. Question number 778. A judgment given by a competent court can create estoppel by record, estoppel by deed, estoppel by recital, estoppel by matter in piece. Here correct answer is option A, that is estoppel by record. Question number 779. A person cannot deny a statement previously made. Estoppel, waiver, denial, none of these. Here correct answer is option A, that is estoppel. Question number 780. A intentionally and falsely led B to believe that a plot of land belonged to him. On that basis, he induced B to buy and pay for it. Afterwards, the plot of land became the property of A. A brought a suit to set aside the sale in favor of B on the ground that at the time of the sale he had no title. In such suit, A may prove want of title at the time of sale. A cannot allowed to prove the want of his title. It depends upon the value of the property. All of them are incorrect. Here correct answer is option B, that is A cannot be allowed to prove want of his title. Question number 781. The principle which preclude a person from denying some statement previously made by him is known as estoppel. Question number 782. Which one of the following is not a case of estoppel? Here correct answer is option A. Palvinder Kaur versus State of Punjab is not a case of estoppel, whereas Pickard versus Sears is related to estoppel. Shri Krishna versus Kurukshetra University is also related to estoppel, and 𝐮𝐳𝐝 versus Gopal Chandra Laha is also related to estoppel. Question number 783. What is estoppel? Option A. Prohibition from proving certain facts is estoppel. Question number 784. Which of the following does not figure in section 115 while dealing with applying the principle of estoppel? Here correct answer is option A, that is conduct. Whereas other options are act, omission and declaration figure in section 115 while applying the principle of estoppel. Question number 785. Which of the following statement is not correct? Here options are: a rule of law cannot be nullified by restoring to doctrine of estoppel. Assurances held out but not incorporated in an agreement would not attract doctrine of estoppel. Plea of promissory estoppel shall be available even if an officer of the government acts outside the scope of authority. And option D, an estoppel arises as soon as the relationship of landlord and tenant is created and tenant is not permitted to deny the title of his landholder. In question number 785, it has been asked which of the following statement is not correct. Here option C is not correct. Question number 786, which of the following statement is incorrect in the context of estoppel as dealt in section 115 of the Indian Evidence Act 1872? Here option B, that representation must be in writing, is incorrect, whereas there must be a representation by a person to another is correct. The other person have acted upon such representation being taken as true is correct. The other person should have suffered some prejudice, detriment or disadvantage by acting upon by or by reason of such representation is correct. Question number 787. Which of the following statement is correct? Option A, section 115 of the Indian Evidence Act applies to contracts by infants. Parda-nasheen ladies are exempted from estoppel. A representation made by an agent is effectual for the purpose of estoppel as if it had been made by his principal. An admission by an advocate, even if it is erroneous in law, is binding on his client. Here in this question, it has been asked which of the following statement is correct. Option C, that is, a representation made by an agent is effectual for the purpose of estoppel as if it had been made by his principal is correct. Question number 788. Estoppel is a rule of evidence used as a defense, rule of equity, all of the above. Correct answer is option A, that is rule of evidence. Question number 789. Estoppel need not to be specifically pleaded, should be specifically pleaded, may be specifically pleaded or may not be specifically pleaded. Both B and C are correct. Here correct answer is option B. Estoppel should not be specifically pleaded. Question number 790. Which one of the following is not an exception to the doctrine of estoppel under Indian Evidence Act 1872? Here correct answer is option C. On the question of fact, it is not an exception to the doctrine of estoppel, whereas when the truth is known to both the parties is an exception. On the question of law is an exception, and against the law is also an exception. Question number 791. Mark the correct statement. The doctrine of estoppel is applied only in civil matters. The doctrine of estoppel is applied only in criminal matters. The doctrine of estoppel is applied in civil and criminal matters. All the above statements are wrong. In question number 791, correct answer is option A. The doctrine of estoppel is applied only in civil matters. Question number 792. Mr. X managed to get admission in MBBS course under a false caste certificate. University took 3 long years in verifying and ultimately cancelled admission of Mr. X. Can estoppel work against the university? Here correct answer is option B. No, as the student has committed fraud himself. Question number 793. Under which section of the Evidence Act a tenant of immovable property is stopped from denying a title of the landlord to that property? Correct answer is option B, that is section 116. Question number 794. A tenant of an immovable property can deny title of the landlord to such immovable property after the tenant vacates the property if the landlord is not the actual owner, if landlord has trespassed into a property and his title is defective, in all cases covered by clause 1 to 3. Here correct answer is option A. After the tenant vacates the property, a tenant of an immovable property can deny title of the landlord to such immovable property after the tenant vacates the property. Question number 795. Under section 116 of the Indian Evidence Act, the tenant is stopped from denying the title of the landlord during the continuance of the tenancy. Option A is the right answer. Question number 796. Section 116 of the Evidence Act is applicable to immovable property. Question number 797. Under which section of the Evidence Act a provision as to who could be a witness may found? Correct answer here is option B, that is section 118. Question number 798. Who may not testify? Option A, an accomplice, child, dumb person, lunatic who is unable to understand the questions and to give rational answer. In this question it has been asked who may not testify. Option D here is the right answer. Lunatic who is unable to understand question and to give rational answer cannot testify. Question number 799. Who amongst the following is not a competent witness? Option A, a child, an idiot person, a lunatic person, a dumb person. Here correct answer is option B. An idiot person is not a competent witness. Question number 800. Which provision stipulates that lunatic can be a competent witness? Here correct answer is option B, that is section 118 of the Indian Evidence Act stipulates that lunatic can be a competent witness.